So I'll go on and get started. My name is Ross Miller. I'm one of the assistant directors here at the Quattrone Center, and I'm very excited to present to you some new research that will be coming out in a report sometime in the next few weeks. So think of this as a very special edition preview. We wanted to get this information out, especially with so many stakeholders here and prosecutors here from various jurisdictions as a result of this symposium. Wanted to make sure that we could present this and get a chance to get feedback from you. So before I get started, just to be clear of what presumptive drug field tests are, I realized later I should have actually made a slide to that effect. But if you see that picture over there on the right, when I'm referring to presumptive drug field tests, these are little packet tests. They cost about $2 a piece. They've been used by police for a long time to make an initial preliminary determination if an unknown substance is a drug. If you think about how a litmus test works, it's basically the same principle. The packet has a little ampule with a chemical reagent in it, and the police put the sample in the packet, break the ampule, follow the directions, and then it will or will not turn a particular color, and based on that color, they'll make a determination of whether or not it's actually presumptive for the presence of drugs. So it's been used for a long time. It's a big part of drug prosecutions and cases generally. So why is it something of interest to us, and why have I put this ominous title up here about having potential role in wrongful convictions? Well, one of the big issues with these tests kind of first got on the public radar back in 2016 with some reporting that was done by Ryan Gabrielson, which was done with ProPublica and published in the New York Times, covering a series of events that took place in Harris County, Texas, where Houston is, about a number of cases that had involved the use of these tests, where the people who had been arrested, and in many cases convicted or pled guilty, were ultimately exonerated. There are some that never were, and are still out there that weren't exonerated because presumptive tests have been used in their cases, and once those cases went to a forensic lab for confirmatory testing, it revealed that they were in fact not drugs. So we had what we would think of as a false positive. So in Harris County, what was happening that sort of led to that series of events was arrests were being made on the field test. So if there was a positive result for a field test, that was sufficient for the police officer to make an arrest for drug possession. The unique thing that occurred in Harris County that was a little bit of a procedural fluke, because I haven't seen this happen anywhere else, by some process or just some inadvertence, all the cases that went through the system were still getting confirmatory forensic tests. So even in cases where the defendant had pled guilty or had gone to trial, or the case had been withdrawn, or some other aspect had happened that had diverted the case, they were still ultimately being tested by the laboratory. What happened that sort of made people aware of it is there was a reporter there in Texas that had been covering the issue who reached out to somebody in the district attorney's office for Harris County saying, hey, there's been these kind of funky exonerations in Texas, which are where people were convicted or pled guilty to drugs, then later it turns out there were no drugs. The office investigated. They made some requests to the lab to find out what this may mean for their other cases, and the lab sent back an email and said, sure, we've been sending you these notices for quite a while and letting you know the results of all the tests we do, including these tests which we call variants, which means it's something unexpected. One of the things meaning that there's no controlled substance on something that was submitted under the idea that it would be. So they discovered that looking at cases having been processed between 2006 and 2015, there were 416 of these variant notices that had come back to the district attorney's office that nobody had seen, because a lot of these were just cases that had already been processed, they weren't active, and so these notices had just gone into whatever the iteration of an inbox was for the office. And out of those variant cases, 251, about 60% of them, were no controlled substance. So some of them were cases where a substance tested presumptively positive for drug A, and it turns out it was drug B, or something else, or the confirmatory test was inconclusive. But in 60% of them, it was no controlled substance. So these were cases that had been adjudicated in some way as a drug possession when in fact there were no drugs. So far, out of those Harris County cases, there are 157 no-crime exonerations that are listed in the National Registry of Exonerations. So there are still people out there in Harris County that actually went through the process with these cases that still have this on their record that are as yet undiscovered. It's not just Harris County, although Harris County is the largest group. Nationwide, in the database, the National Registry of Exonerations, there are 328 no-crime drug-related exonerations. And so the situation, what happened in Harris County, what was covered so well in Brian Gabrielson's report on this, it's really the largest bolus we have of cases where defendants pled guilty, a large number of them pled guilty, and they ultimately went into an exoneration. So we have this class of defendants with guilty pleas and no crime exonerations. One of the things that Gabrielson noted in his report is, it won't surprise a lot of people in this audience, but over half of those defendants in the cases that ProPublica examined pled guilty within a week. So these cases came into the system, an arrest was made, very quickly those cases were disposed by way of plea. So, big thing happened in Harris County, lots of reporting, kind of outrageous. It makes everybody worry, you know, this is a huge signal, there's something wrong in our criminal justice system, so obviously it was immediately remedied. Well, it wasn't. And of course, we've seen these errors continue in some high-profile situations and then many other situations that aren't so high-profile. One case in Georgia in 2018, same thing, some arrests had caught the notice of local journalists about the field test kits. They made some requests of the police department, who did an internal audit, found 145 positive field test cases that were reversed. And in all but 13 of those cases, the individuals had been arrested based on that. In Springfield, Illinois in 2020, a gentleman was pulled over by the police. They saw a suspicious container in his car. They found powder inside it, tested it. It tested positive for crystal meth. It was the ashes of his deceased daughter. He was ultimately released, and there was a civil rights suit based on that case. These continue to pile up. There have been things even in just the last couple of years. A case in Georgia where a woman was stopped with a stress ball that was filled with sand. They tested it, said it was positive for cocaine, spent 6 months in jail, ultimately was not cocaine. In that case, she was awarded $1.5 million as a real civil rights suit. A case, Georgia Southern quarterback, they found a mysterious white crusty substance on his car, tested it, positive for cocaine. It was bird feces. Another case of somebody that had a strange, you know, kind of plasticky glaze that was smeared on the inside of the car. He said, yeah, I was just eating Krispy Kreme donuts. That also tested positive for meth, when in fact it was Krispy Kreme donut glaze. And then a case not so long ago, someone had a blue powder in a little bag. The police stopped them. She explained to them, this is cotton candy, tested it, crystal meth. She spent 6 months in jail after being given a bail of $1 million for possession of this 1 ounce bag of blue crystals. And then one that came up recently that just, you can't make it up. A trucker who was driving a large rig, a tanker rig, that was marked that it contained diesel. When the police saw the vehicle stopped, noticed that there was some crystallization around parts of the truck and in some of the drums that were being offloaded. They tested it, again, crystal meth. He was jailed for 6 months. It turns out that the tanker marked diesel was actually filled with diesel. So this is a problem that's been continuing. It happens in a lot of different situations with a lot of different substances. So there's a group out there, Roadside Drug Test Innocence Alliance, who's been doing phenomenal work in the space. The founder, Des Walsh, made the trek from LA to be here today and be part of the symposium. They've been doing work. They were motivated by these stories out of Texas and this idea that there are these folks out there who have not yet been discovered, who have these marks on their record, in some cases could theoretically even still be in jail when they didn't commit any crime. And there's actually evidence to that effect because those cases weren't processed. Des and his team came to us at one point to talk about this problem and that they wanted to find better sort of scientific ways to think about it and to get a better understanding of what the scope of this might be nationally. So as a result of those conversations and in that partnership, we devised a couple of different ways to go at this problem. First off, we also discovered pretty quickly that there really was no empirical data in this field. There's never been any empirical studies of error rates. There's information out, some of it is actually produced by the companies that make these tests, that explain that there are a number of household things that can cause false positives. But in order to get an error rate, you kind of have to know what the whole universe of possible substances is, which is pretty challenging. So that work hasn't been done. But in the cases where there have been audits in departments and looking specifically at cases where the tests are used and what happened in those cases, the numbers are pretty concerning. In that Savannah police case that I referenced before, there was a 14% false positive rate for tests used for cocaine and ecstasy. In a 2016 case, this is actually from the ProPublica article, from the Florida Department of Law Enforcement, a 21% false positive rate on tests involving crystal meth. And more recently, as a result of a class action suit that was brought in Massachusetts because of drug testing that was being done by the prison system, it was discovered by the prison system doing an internal audit that they had a 32% false positive rate for synthetic cannabinoids and Suboxone, which they had been testing for in male. So when other departments and people have actually looked at this issue once something has been raised, the things that they've discovered have been pretty concerning. But those are sort of still kind of anecdotal accounts. They're just individual situations, and so we wanted to find a way to figure out what the scope might be on a national scale. So what we did is said, hey, why don't we go ask the people that know? The people that have the best information about how often these tests are being used are the law enforcement agencies that use the tests. So we wanted to conduct a survey of those agencies to get information about the frequency of their use and arrests. To do that, we just sampled the top 10 jurisdictions by population in each state. We wanted it to be nationally representative, and we wanted to have enough population so that we could make we could do some good statistical analysis that would give us some confident numbers. And for that, we used a survey instrument. We also did it among prosecutors' offices. As I'll show in the slides in a moment, our response rate wasn't very good with the prosecutor offices. So we got some information, but it's more about kind of how these are being used and how they're accounted for in the criminal justice process. In addition to that survey, we're analyzing police arrest data from the data that's submitted to the FBI, the Department of Justice. These acronyms SRS and NIBRS, that's the National Incident-Based Reporting System. This is the data when you see the crime in the United States reports and a lot of the estimates that are made about crime in the United States. It comes from these data that are submitted by local law enforcement agencies. And so using those in combination with the responses and the data we collect in the survey, we wanted to develop a statistical description of how often these tests are being used in the field, what the potential impact of these tests could be on wrongful arrests and prosecutions, and then look at many of the other things that come to mind, including possible disparate impact by race, ethnicity, or other demographics. So we got a pretty good response rate from the police. As I said, it was a little bit more of a struggle with the prosecutor offices, but we did get good national distribution. We wound up with 77 law enforcement agency responses that we could use that had complete data and had the information that we needed. The prosecutor numbers are lower, but we did get good national distribution of those. In terms of how representative that group was, with the police, we got agencies covering a population of 22.5 million people, which is a little shy of 7% of the U.S. population, and from the prosecutor offices, a little bit less than 7 million. So we got responses from agencies that served pretty large populations, which is what we were looking for in order for us to be able to do the work that we were seeking to do. And so what we found, just tells you a little bit about this kind of main response. The main question that was posed to the respondents was, how often in drug-related arrests are presumptive tests used? And so what this distribution shows you is kind of where when we put those responses together, it basically comes out with a raw average of right at 50%. As you see in the column on the left, there were a number of jurisdictions, 20, that reported they didn't use those tests at all. If you look at the column on the right, there's a little over 20 that said they used them almost all the time in the 90 to 100% range, and then you see kind of how they distribute between them. So these percentages of the drug test, the drug arrest involving tests, we take that information, we use it in here. What I'm showing on this slide is this figure, 1.57 million yearly drug arrests. That number comes from the annual crime in the U.S. reports, which are the estimates that the FBI has been producing for decades. So we take that number, looking at those data from 2010 to 2019. The ultimate report, there's going to be some additional statistical analysis, but the numbers are right around that same ballpark. Some of the other things we learned from the survey, as I said, we did get some responses from the prosecutors. What we learned from the prosecutor offices was pretty consistent with existing literature in the field about how drug cases were processed, as you see, involving these tests. As you see, the vast majority of the offices that responded said that they do permit guilty pleas without confirmatory testing. It was only in one jurisdiction where they said that they actually will go to trial without confirmation testing. And then what are the chances of this being tested after plea? Obviously, pretty unlikely, and testing after trial, pretty unlikely. So this was consistent with what we kind of knew going in and didn't discover any surprises there, although some of you might be surprised at the one yes with trial permitted without confirmation, and we can talk about that later. But the other question we had for the prosecutor offices was, are these having any impact in decisions about detention? So as you see here, some of the majority of the offices that answered the question said that they did not recommend drug detention in didn't recommend detention in drug possession cases at 60% of them. 40% said that they did, and among those said, when you do make that recommendation, do you consider the drug tests? The majority of those said no, and some said yes. As I said, this is more descriptive. We didn't get a huge response rate, and I think there are lots of reasons to believe that that is not nationally representative, but it's interesting data nonetheless about how these are being processed in prosecutor offices. So the big question is, what does that mean for the error rate? Okay, and as I mentioned, in terms of determining a true error rate for these tests, it would be exceedingly difficult to try and do it based on the tests themselves failing to produce the result that they're designed to produce, because you have to know so much about the universe of substances that can trigger this false positive rate. But what we can know, looking at various different sources, is what the chances are that when these tests are used in a drug case, based on both these audits that we looked at and then what we now know about their rate of use nationwide, we can get some ideas about how many cases could be affected by the use of these tests. So one of the things we wanted to figure out is, well, where's kind of a starting point to think about error rates in drug cases generally? This is one of the places where the Roadside Drug Test Alliance, Innocence Alliance, had been doing great work trying to identify the people that were affected by this, and have been involved in a process of making FOIA requests to get information from drug labs about their negative results in confirmatory cases. That data was shared with us, and using that data from a number of different jurisdictions, we were able to see that just from a straight forensic confirmation level, there was about a 3.6 negative confirmation rate. So one way to think about that is kind of that's sort of a rate just in drug cases generally, where stuff is going in, the submissions are going to the forensic lab, they're suspected as drugs, and they're coming back as no controlled substances. As we mentioned before, those audits come back with these higher rates, 14%, 21%, and 32%. We can't say those numbers represent what happens if you were to look at all these cases at once, but those are all real jurisdictions that looked at a broad swath of cases in order to determine those numbers. So for our purposes, to talk about what this might mean in terms of wrongful arrests, or the idea of people who are arrested or go through the process as a result of drug possession cases, we're estimating, using those numbers I talked about before, kind of taking the sort of national statistics with respect to a little over 1.5 million drug arrests. If 50% of those involve the use of field tests, you're talking about a little over 650,000 cases in the United States every year, arrests every year that involve the use of these presumptive tests. So thinking about that in context with what we do know about known examples of false positives with these tests, looking extremely conservatively at just, hey, here's a number that we've learned actually represents an error rate, a way to think about it in a broad context of drugs, and that's at 3.6%. So at that number, you're talking about potentially 28,000 cases across the country where someone has been arrested and a process has begun in a prosecution for drug possession where it's a false positive. If the presumptive test was used and it indicated a false positive. As you go up the ladder, the numbers get bigger. If that 14% number is representative in a jurisdiction, or that averages out to be the way it is nationwide, you're over 100,000 cases. At 21%, you're over 164,000 cases. And at 32%, which is an astronomical number, you're at 250,000 drug arrests. So you're talking about potentially large numbers, hundreds of thousands of cases every year that are using a technology and a presumptive test that is known to have a significant error rate, but that error rate is not known. So looking at these numbers, it's pretty shocking. It was surprising to us when we saw what we were learning from looking at all these different examples where these had been audited in the field. And so, again, it's important to note here, what we're talking about here are cases looking at arrests, and we're looking at this total universe of cases where drug possession is charged. So as you know, there's a lot of things that happen between an arrest and a case moving into the criminal justice system and the outcomes that you have in the criminal justice system. So to think about how these numbers potentially relate to the idea of wrongful prosecutions, you've got to take a step back and kind of understand the context of drug cases generally, and what we know sort of from exonerations. So first, just thinking about drug cases. As I mentioned before, the annual number of arrests is somewhere around 1.5 million cases a year. No one knows that figure with absolute certainty, but we have good estimates. Those estimates have been pretty stable. Our novel techniques that we're using, as part of the report are fairly consistent with those numbers. And so this chart here just kind of shows all those drug offenses are on the left. Everything in the orange and the gray are the index crimes. So for those of you who may not be familiar, the crimes that have been historically reported to the FBI through the UCR system, they look at these index crimes. Those are all the kind of big crimes you think about. In the orange section are the property crimes, which is theft, burglary, motor vehicle theft, arson. In that gray box to the right are violent crimes, arrests, aggravated assault, robbery, rape, and murder. So what's helpful just looking at this graph, obviously the numbers speak for themselves, but when we're talking about drug cases, we're talking about an enormous share of the landscape of criminal justice events, an enormous share. Now there are crimes that aren't represented on this graph because there's a lot of crimes out there, so you can't put them all in one graph, and so those blocks on the right are going to be bigger, but that block on the left is going to stay big. So we know it has a huge share, and when you look at this, thinking about wrongful convictions as something we want to identify and prevent, that little box over here on the bottom right, this kind of rectangle, robbery, rape, and murder, a lot of our discussion about exonerations is over in that box. That's the share of cases that we're talking about. They're important cases, and the stakes are extremely high, but it's actually a very small share of the overall criminal justice landscape. When you think about things like DNA, which is something that comes up a lot in our world, DNA, if there was a box representing DNA on here, the cases that involve DNA, you wouldn't be able to see it. You're talking about something that's probably fewer than 1% of cases. Again, I don't know what the current estimates are, but traditionally they've been somewhere in that neighborhood. So I think to think about the implications, it's important to understand that landscape of drugs and what they represent in the criminal justice universe. So there are a couple other reasons to think this is potentially a very significant source of inaccurate criminal justice processes. These pictures here are from a report that's promulgated every few years that's a survey a census of the National Forensic Laboratory Information System. This was taken from 2019. It's about 162 forensic labs across the country that report back to the DEA about their practices, what they're seeing, so that they can compile some statistical information about what's going on in those labs. And just a couple of interesting figures here. As you see over on the left, reasons that cases were not submitted to the laboratory overall and by lab type. You see these big bars here for the defendant pleads guilty or a plea bargain is reached before or without submission to a laboratory. Overall, looking at federal and state, it's about 60% of the cases. So that just kind of confirms what we can infer here, that when cases plead guilty or reach any kind of plea bargain, that generally stops the process of confirmatory testing. Down below it, you also see another section they reported in that same section of the survey, that they were field tested, and they're only submitted when confirmatory testing is needed. Unclear what that means, but the number is over 22%. So there's a lot of cases that aren't being submitted to forensic labs for some reason that we know were field tested and they just have elected not to go forward. Looking on the right side, some similar information, the reasons that they were not analyzed. These have been submitted but then just don't get analyzed. Again, a little over 50% because of guilty plea or plea bargain, 43% adjudicated without forensic evidence testing, which feels a little circular, and then down below, a little over 7% for presumptive identification. So this is another source of information saying these are out there having a real impact on the way these cases are being processed and how few of them go all the way through that process to confirmatory testing. So to think about it from an exoneration standpoint, looking at the data from the National Registry of Exonerations, it's actually 3311 as of today. But there have been a total, if you look at just the pie chart there to the left, out of all those exonerations in the National Registry of Exonerations, which is our best data source currently for that universe of cases, 22% of those cases are for drug offenses, a little over 2,700. The big Pac-Man is for non-drug offenses. And if you look at that pie chart to the right, the vast majority of those, again, no surprise, they were by guilty plea, and only 115 a trial, 470 by guilty plea. So the role of plea bargaining is obviously playing a significant role in how much we know about those cases and whether or not they were actually drugs. Now, this is just looking at the individual cases in the National Registry of Exoneration. As you'll hear, if you're here tomorrow morning, I'm doing a panel, hosting a panel talking about the groups registry. And if you take into account the groups cases, looking at the groups cases, which are looking at a little bit of a different category of case, where a large group of defendants was ultimately, some of them are exonerated by definition, some of them are not, but where there's been a material failure that has ultimately led them to be an analog of an exoneration. You look at those, 93% of the it takes your combined number up to almost 40,000 cases that have been known and documented in the registry, the groups and the individual. 93% of those cases are drug offenses. And as you see, it's just that much smaller slice now of the cases that aren't. So these drug cases are contributing to, not contributing, these drug cases are the lion's share of these sort of known cases with these significant material defects, whether they're true exonerations or some other complete failure of the system. Now, for some of you that may be familiar with the groups registry or where that comes from, there is a category of cases in there that come out of the Massachusetts drug lab scandals that was sort of emerged in 2018. Annie Dukin, who was a forensic analyst there, had a lot of issues, and ultimately tens of thousands of cases were thrown out that were all drug cases. So one criticism you can launch at this is like, oh, well, that's kind of an unusual situation, so you can't count that because everything was going through one person. But even if you take out those Massachusetts cases, which are a lot of cases, that gets you all the way back down to 7,000 cases, you still have a 62% share of all the known exonerations are drug cases. So the important takeaways here, and there will be a lot more granular information in the report, which, as I said, will be out very soon. We don't like to make like bold claims often, but this is one that potentially warrants that. The first takeaway here is, based on what we have been able to analyze and observe, but based on the case volume and the share of criminal cases that are drug cases, and the likelihood of pleas, drug cases are very likely the largest category of wrongful arrests and prosecutions in the United States. Some of that is just kind of borne out by the share that they represent and the raw numbers of arrests. Also, the use of presumptive field tests, because they generate those cases and sort of put those cases on track into the system, that could be the largest single contributing factor to wrongful arrests and prosecutions in the United States. And the other thing that's very important, and this will be emphasized in the report, your mileage will vary. That hazard ratio, the idea of what this potential risk is in any given jurisdiction, all depends on how your jurisdiction would answer that first question. If you live in one of the 0 jurisdictions that doesn't do the field tests, well, the field tests themselves are not posing much of a risk. If you live in a jurisdiction that tests 100% of their cases, that risk is a lot higher, and the hazards for everybody involved in that criminal justice system are significantly higher. And that's going to be dependent on what that local testing rate is. A couple of things just as possible points of intervention. Obviously, one is to decriminalize or legalize drug possession. In the unlikely event that that's not quickly arrived at as the best solution by every jurisdiction in the country, you can go to some of these other ideas. One is to simply require confirmatory tests prior to any detention or disposition. There's going to be pushback about that because they cost money, and a lot of things have to go into the process for those to happen. Something that has happened in sort of isolated cases or conditional pleas. There are lots of reasons why people who are in jail or have some other reason why they need to move that case along, they can't wait for a case to go to testing, potentially use a conditional plea. They can get all of the benefits they're seeking from doing a plea, but the case can still be tested in the event that it is in fact not drugs. It can retroactively be expunged. And then, of course, there are ways to improve presumptive testing. There are other technologies out there. They're new. Some of them are a little expensive. They also have kind of unknown error rates, but they seem to be lower. Raman spectroscopy is one of those technologies. It goes by the name TrueNarc. Some of you may have heard of those machines. It looks like it's probably better, but there's also limited empirical data about how well that works. So that's field drug tests. Well, that's a long one. When your slides talk about drug arrests, is there a breakdown between K&I and PWID? That's a good question, and I'm guessing that's somebody from Philadelphia. There is not a breakdown. So when we talk about those arrests, that's just looking at what is defined in the UCR data as a drug abuse offense. So they are all together. And obviously there are different things involved in different types of cases, but in both of those, possession with intent to deliver, I should have said, is what I'm assuming PWID means here, versus simple possession. Both of those require that the substance at issue is in fact a drug. I see also you compare these tests to DNA, but these are probable cause tests, which is very different from proof beyond reasonable doubt. Result means over 50%. Isn't the error rate even from your data far less than that? So that kind of gets to the heart of the potential issue here. It's very important that you take away that we're not saying there is an X% error rate. The issue about proof beyond a reasonable doubt, and the tests themselves, the packaging for the tests say these require confirmatory testing. Don't rely on these tests. The reason why the reasonable doubt issue is not really the metric here is because that is not how the cases are being processed. If we lived in a world where all the cases were going to trial, they were being adjudicated with a neutral fact finder, and all of those things are being implemented, then a reasonable doubt standard could be something that would protect us from this, because forensic testing is one of the things that's required. As I mentioned, there's one jurisdiction where there is case law that allows presumptive tests to be used to prove a case beyond a reasonable doubt. So there is one jurisdiction where that is actually part of the law. And then another question here, and who would ever go to trial without a chemical analysis, and why? And that's exactly why, because there are jurisdictions that permit it. So any other questions? I think everybody wants to get to snacks. So the report will be out sometime in the next few weeks. Thanks very much.